For pronouncement of judgment, item 1 to 5.
Resultantly, the writ petitions are allowed the impugned judgment dated 21st of August 2023 passed by the learned single judge in writ petitions number 3341 2019 and 3344 is set aside. The APS is directed to declare the result of the appellant within a period of 2 weeks from the date of production of certified copy of this judgment and order and forward the same to the state within 1 week from the date of declaration of result. The state government is directed that on receiving a recommendation from the APSC as directed above, it shall provide appointment to the appellants on the post reserved as per the direction of this court and as per their merit within a period of 4 weeks from the date of receipt of recommendation of the APSC. During the course of the hearing of these appeals, the learned counsel appearing for some of the appellants and other counsel for the remaining appellants have fairly submitted that if the appellants are granted relief on the basis of equity, they shall not insist to grant them service benefits from the retrospective date and are ready to accept the complete service benefits from the date of joining of their respective posts. In such circumstances, it is ruled that the appellants will be given all the service benefits from the date of joining in the service and not from any retrospective date. Before parting with the record, we may add a word of caution for the APSC that while conducting the combined competitive examination in future, it shall make every effort to conclude the combined competitive examination and all other examination with full responsibility in a fair and transparent manner. The preparation of the answer keys and declaration of the result to be carried out in a foolproof manner without leaving any ambiguity in the minds of the candidates or the public at large. With these directions and observations, these appeals are disposed of. No orders has been passed.
DP of license.
Of the other side, I beg to mention item number 6.
Item number 6.
6.
Is it? Item number 6. You are appearing for?
Appellant.
What do you want? What do you want?
After vacation,
The order matter, let us see. If any forward order is to be passed, then we are not going to. Wait for your turn.
interim order may continue.
Wait for your turn. Yes.
Lordship, I beg to mention item number 20, Lordship.
20.
Yes, Lordship. I am for the appellant, Lordship.
Adjourn.
It is, Lordship, I beg to mention item number 23.
23.
Yes,
Yes.
I'm paying for some time, Your Lordship, in the matter.
You are
For the appellate,
for time.
an adjournment, Your Lordship. That's what it was.
Adjourn.
Lordship, I beg to mention item number 33, Lordship.
Yeah.
Time for the respondent, Lordship. I need to some time to file my affidavit, Lordship. Response, Lordship. Lord.
Adjourn.
Oblige.
We are for the appellant. We are for the appellant. May I please, Lord. Beg to mention item number 24. 24, we have taken consent from
Adjourn.
the.
Adjourn.
May I please, Your Lordship? Lordship, I beg to mention item number 29 of today's list. There's a connected matter 30. In 29, we have been engaged recently. The Wakalnama is awaited. So 29 may be adjourned, Lordship. But
February.
Well, item number
February.
item number 29 and 30 are tag matters relating to Kamakhya corridor. Well, both the matters may come up together.
Both the matters are.
Not-
February.
May please, Your Lordship. I beg to mention
I am in item 30. I've come. Lordship will recall the matter was fixed. No, I mentioned the matter. 29, 30.
30.
My learned friend didn't tell us that they were mentioning the matter.
No, we informed you 29.
No, you didn't inform me. I'm sorry.
29.
29 is separate. I'm in
Yeah,
30. That's a
30,
separate matter.
30 is different.
You can't do that. This
You're
is not being
appealing
fair
in
to me,
which
Milad.
29.
29,
Twenty.
and you are appealing in.
I'm 30 minutes. And Milad, I lordship will
So,
recall.
both have to be heard together.
Yes, Milad. No, but the point is, Milad, if your lordship will recall, I had mentioned the matter on VC because I said coming for the matter physically, and which is why I've come for this, Milad. So they should have at least had the courtesy, Milad, to seek.
Naturally. They're not informed that.
No, Milad.
No, 29, when we wanted,
The connected matter is there.
no, we informed,
No, I'm not free.
that's what was
My
informed.
instructor lawyer told me we had a conference yesterday evening. We are not,
No,
we are
that-
entirely
what
unaware.
what
Let the
he-
matter come up in its turn, Milad.
Things, please, settle it out of the court. Why you
No,
making all these matters?
My instruction was that you were informed by the junior
If
advocate.
the advocates,
No, I am aware. But Milad, then let the matter be taken up on its turn, then we'll see, Milad. Let the matter come up.
let the matter come, it's okay, fine.
I'm grateful.
May I please, your lordship. I'd like to mention item number 27, my lord.
Yeah.
The council, Mr. A.R. Bhai is undergone surgery and he is recovering, but not in a position to resume the court, my lord. May I pray for adjournment after a vacation, my lord?
Adjourn.
After the vacation, my lord.
Adjourn.
Hello.
Yes.
I beg to mention item 42 of today's daily list. Item 42,
42, yeah.
I appear for the respondents in this matter, Lordship. Some instructions are sought for, so
Have you informed the other side?
Yes,
Then
Lord.
again, somebody will
I
come
have
and
informed
say,
Lordship.
adjourn.
I'm obliged, Lord.
And why don't you circulate the adjournment slip in advance?
I'm sorry, Lordship.
What do you mean by sorry? Every day I'm reminding you and people are,
I'll do it, Lordship.
Mayor, I beg to mention item number 41, my lord.
yeah.
The matter is fixed for hearing today in the Director of Land Revenue Service, my lord.
Matter is fixed, then why it is here?
Yeah, there is a appeal filed by the respondent here, my lord. The appeal filed before the
Then why this appeal is pending here? When the matter is already there, why this appeal is here?
appeal before your lordship, we have challenged the single bench order, madam.
Single bench has remanded the matter.
No,
Then
appeal filed before the Commissioner of Lawyers and Division. The matter is pending there. In the meantime,
adjourn.
May I please, your lordship, concept of the other side, I beg to mention item number 40, lordship.
40.
Yes, lordship. Kindly make a mistake.
Adjourn.
Oblige, lordship.
In item number 39, there is adjournment slip. Who is appearing for 39?
Item 39.
There is an adjournment slip. Mr. Chaudhary.
Yes, Mila. Yes,
Adjourn. Adjourn.
I think the other side did not agree. That is why, my lord, we did not mention. We circulated the letter.
Let the number.
Yes,
Any other request?
My lord, I am praying for listing a appeal, my lord.
Next week.
Daily list for orders, item 1.
my lord, actually, I appeared at some point of time.
Yeah.
But the instructing council is no longer, my lord, there. So may I pray, my lord, the matter may be listed after the vacation. I'll ask my junior to get in touch with.
There are some steps to take on the last week. Responsible to take for some time to correct his steps.
देखिए sir.
Mr. K. Jain was appearing.
A Karishma Jain, yes, my lord.
And,
Actually,
in 2 weeks.
she has
time,
got a
take
baby and all.
Effective corrective steps and seek apology for conduct. So this is what the year passed on 19/4/2024.
That's why, my lord, I'm also having some communication gap. Let me go through the brief, my lord. Let the matter be called after the vacation. I'll see what can be done, my lord.
King Chaudhary, Senior Counsel, please.
কিবা এখন এফিডেভিট দিবলগীয়া আছিল না খুজি পেলাই সেইখন আজিলৈকে দিয়া নাই
You are appearing for whom?
Actually, she is with me, my lord.
What's your name?
N. Mahanta.
Look here, MS N. Mahanta. appearing for the petitioner face some more time to comply with the direction given by this court on 19/4/2024, list after into grade.
Item 2.
Respondent number 11 to 14 and 16 to 36 have not been served.
Yes, Lordship. Shipul. Yes, Lordship. Yes, Lordship. Lordship will need some time then.
For what?
Lordship to take steps, Lordship. Fresh steps, Lordship.
Okay. As per the office report, the notices issued to the respondent number 11 to 14 and 16 to 36 are still awaiting. Stop. Then it concerns the petitioner is directed to take fresh steps for service of notice upon the aforesaid respondents. On taking such steps within a period of 1 week, on taking such steps, that notices will be issued to the aforesaid respondents returnable on 6 weeks.
Lordship.
Item 3.
Here, your lordship, yesterday evening, I have received the instruction, your lordship. It's a slightly voluminous, your lordship, if you, your lordship.
What instruction?
Instruction, your lordship, we have identified 6,250 numbers of your lordship. Extremely vulnerable families, your lordship. Among the
Vulnerable.
families, your lordship. And now I want to bring that by way of an affidavit.
Mr. Board have to waste some time to bring some additional facts on record.
Lord,
Start to 6 weeks.
deeply obliged.
Item 4.
Respondent. Well, I received the otherwise comment, my lord, I'll file affidavit within 3 weeks, my lord. On behalf of the respondent number 1.
On behalf of the respondent, what about the other respondents? All the respondents? that-
No, not all the respondents, my lord. I am on the,
How many respondents are there?
there are 5 respondents, my lord.
Not 5, more than that.
And 5 originally, sorry, my lord, originally 5. Yeah,
9 respondents.
9 respondents. All the states have high.
As per the office report, notices upon all the respondents have already been served. This petition will be listed for admission. Let this PIL petition be listed for admission after 6 weeks. In the meantime, the respondents may file their
My lord.
desire so.
Deeply obliged.
Highly obliged.
Item 5.
We have filed the affidavit against today itself, my lord.
That is there on record.
My lord, we filed it today itself. Today. Received the copy. So they have already received the copy, my lord. So let the matter come up on Friday. Or...
Service of notice upon the respondent is already effective. Let this matter be listed for admission after 8 weeks. In the meantime, the concept of the respondents, in the meantime, the respective respondents may file their response to the writ appeal if desired so.
We have filed a reply for respondent on to the matter. We have got a reply already filed, madam.
Bless you. May please, your lordship.
Admission के लिए just for admission.
If a date can be given after 4 weeks, not 8 weeks, it's slightly long. It's okay. I'm grateful.
4 weeks.
I'm grateful.
Long vacation.
Item 6.
This service is complete on the last occasion also. Okay. This court has already noted, this court has already observed on 8/11/2020 that the service of notice upon the respondents is complete. Is this matter for admission after 8 weeks, interim order intended to continue till next week?
Item 7.
May it please your lordship.
Respondent
My lord, relying upon that,
notice has not been received, sir.
my lord,
Respondent number 4 notice has not been received.
so my lord, it's a new matter.
Item number?
7, review petition, my lord. Yes. Now, my lord, your lordships had decided the matter from the perspective that this concept of neighborhood is something different from area of operation. My lord, I'm not questioning that. But my lord, your lordship did not take note of 2-3 documents, my lord. Yes, please come to my lord, page 94. It's a part of the writ appeal, my lord. This is the certificate of registration of the respondent society. Kindly see, my lord, in the matter of application of Sri so and so others for registration of a cooperative society at so and so places, I do hereby certify that pursuant to section 11(2) of the Assam Cooperative Societies Act, the said society has been registered in my office as a cooperative society with limited liability under title so and so, so and so, so and so, dated 21st April of the year 1997. So, my lord, 21st of April 97, this society was registered with the following, my lord, villages. Now, my lord will kindly come to their reorganized certificate at 110. The society was reorganized. This was, my lord, page number 65 of the writ appeal. Certified that part 2, number 5, Kolongnodi Ansolik means Samabhai Samiti is a registered cooperative society under the Cooperative Societies Act and the rules, bearing registration dated so and so. The village covered by the society are so and so. Now, please come to the last, this is a subsequent, my lord, subpara. This society deserves settlement as all the members of the society are catching fish. In this connection, preference may be given as practicable to the reorganized fishery cooperative society located in the neighborhood of Fishery Mahal, number 25 Bipuzijan and number so and so. They are not in, my lord, the neighborhood of this fishery. Therefore, my lord, that report which was given by the circle officer is wrong. So, the issue is not whether they are in the neighborhood, issue is whether they are in the neighborhood of the fishery at all. So, page 94 is the original registration certificate. Page 110 is the reorganized registration certificate. Now, please come to page 175, my lord. The same circle officer has given this certificate. Page 175. Now, this is by the same circle officer. With reference to the subject cited above, I have the honor to submit herewith the following list of villages from the Min Mahal so and so. Kindly see, Maloibari is 22 kilometers away, Hub Maloibari is 24 kilometers, Amor Pathar is 15 kilometers, Depohal is 16 kilometers, Bezeni is 14 kilometers. So, where is the question of they being within 1 kilometer, my lord? So, my humble submission is, my lord, the government should look into all these aspects and decide the matter afresh. Otherwise, in terms of the land single judge's order, my lord, this society which is not even in the neighborhood, they will get the settlement. So therefore, the in the ADC's order where it is said within 1 kilometer, that can't be correct because these are the report of the circle officer. So this aspect was not taken note of, my lord. Therefore, my humble submission is, my lord, at page 133, based on the subsequent circle officer's report, the ADC has given an order based on my representation. If your lordship would kindly come to page 133, the last two sentence. Neighborhood certificate submitted by number 11 so and so, that is the respondent 10, in the tender paper bearing was examined. Through certificate is incorrect, as none of the operational area of the society is situated in bank of the river so and so. Majority of the society as shareholders reside in Nis Govardhan, which is situated in the bank of river Kolong, 1 kilometer from so and so. This 1 kilometer is also not correct, Miller.
Mr. Chaudhary, which page?
Page 133, Miller. This was the order which was passed based on our representation, where based on the report of the primary authority, a view was sought to be taken that they are in the neighborhood of another fishery, but within 1 kilometer. That is also not correct. The last two sentences, the neighborhood certificate submitted by number 11, part 5, Kolong Nodi Ansolik Min Samabay Committee in the tender paper bearing dated so and so was examined, and it was found the information provided through this certificate is incorrect, as none of the operational of this area of the society is situated in the bank of Kamrup so and so Brahmaputra fishery jurisdiction. Majority of the society holders reside in so and so village, which is situated in the bank of river Kolong, 1 kilometer distance from the Pragjidishpur. Even in my humble view, Miller, even this is not correct, going by the report of this primary authorities. In that view of the matter, this was not taken note of. That.
Those for orders.
Item 8.
Who is appearing for the, this item number 8? Respondent number 4 has not been served till date.
We have taken the steps. It has been dispatched, but the report is not there. That's what the
Report is
office.
not there, and it's since long there.
Yes, my lord.
Once
We have taken steps on 26th of July. It was dispatched.
Take fresh steps.
Very well.
As per the office.
Very well.
The notice of the respondent number 4 has not been served till date. When they consult for the appellant, directed to take fresh steps for service of notice upon the respondent number 4 through registered AD and Dusty within a period of 1 week of taking such steps, let notice will be issued to the respondent number 4, returnable 6 weeks thereafter.
The interim protection be extended.
Interim order is intended to continue till next.
Obliged, Lordship.
Item 9.
May I please, Your Lordship? We have filed affidavit of Dusty Service.
Where is your affidavit?
Filed on 28.
Notice of served upon personally?
Yes, ma'am.
Okay, and, additional affidavit is filed on behalf of the appellant. Along with the acknowledgement proof of receipt of notice, along with the proof of service of notice upon the respondent Shekhar Kanti Dev through speed post. Taking into consideration the above, the service of notice upon the respondent number 4 is deemed to be complete. Office to take note of it, place this writ petition after, writ appeal after 8 weeks for admission.
It is already admitted, ma'am. Already admitted on 5/8, ma'am.
This is a field in report.
Item 10.
Map is your lordship.
11 to
19 and 6 to 9 lordship.
9 and 11 to 19.
Service report is awaited lordship. Lordship may kindly taken up after vacation lordship so that
I'm for private respondent, my lord. 6.
Await return of notice of unserved respect. For
6 to 9.
Lordship,
I'm for
my-
6 to 19 except 7 and 14, my lord.
6 to 19. You are
Except 7 and 14,
except 7 and 14.
my lord.
Okay, as per the office report, notices upon the respondent number 6 to 9 and 11 to 19 has not been received till date. However, Mr. So and so put in appearance on behalf of
Respondent number 6, 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, and 19.
let notices of the remaining respondents be awaited for 4 more weeks.
Lordship may kindly fix the date lordship.
The notices be served, then we'll fix the notice. Yes,
Yep, yep.
then we'll fix the date.
Lordship.
Item 11.
My pleasure, lordship.
Respondent number 18. Await return of notices of respondent number 1 and 2 for 6 more weeks.
Obliged, lord.
Item 12.
But the notice upon this sole respondent is still awaited, my lord.
Take fresh steps.
Yes, my lord.
Okay, notice issued today. Respondent number 1 has not been served till date. When it concept of the applicant is directed to take fresh steps for service of notice upon the respondent number 1 within a period of 1 week. On taking such steps, the notices be issued to the respondent number 1 returnable through registered posted date. Yes, that's the
Obliged, lordship.
within a period of 4 weeks.
Item 13.
Well, in this case, notices are issued and the other side appeared for taking time to file objection. By this time, what they did, my construction has been demolished, my lord.
7, 8, 9, 10 and 11.
That is by registered post, my lord.
It has not yet
That
been.
has not been served till date.
But by this time, my construction has been demolished, my lord.
What to do then? Notices have not been served.
But the respondent number 3 has carried the construction, demolition works was carried by them.
Whatever it may be, sir, we have to await.
But others are the private respondent, my lord.
Then we have to await the notices of the other respondents who have not been served. We can await return of notice of respondent number 7, 8, 9, 10 and 11, 7 to 11 for 3 more weeks.
Right.
Item 14.
And this is the OBB teacher
Why
for
7 days. Why?
my lord is the already disposed of your lordship, my lord, regarding the old pension and new pension. By concluding, all are disposed of my lordship. Dispose of police. It pays flex mark, my lord. On 1/12/2024. Only my lord delay, there is only, is it 490 days? Yeah.
This delay is
Delay is only minor,
only,
minor.
but it is something late, not only. 537 days.
537 days.
Both the matters are same.
Same minor. There are 493 days minor. They are disposed of matter minor.
Delay.
Next is also same minor. Mark.
For admission, item 16. 16 to 18.
Please, your lordship. My lord, your lordship directed us to obtain instruction.
Yes.
As to whether, my lord, at the time of taking over the, my lord.
Hey, liability was fastened upon you or not?
Yes, my lord. I have received the instructions, my lord, written instruction. The judgment of the appellate authority, my lord, your lordship may read the. I'm sorry. Yes, sir. What is the people want to say? Yeah, I'll put him. Within minute. Yeah. Okay. Okay. Okay.
So this school falls in which unit?
My lord.
The school falls in which unit?
School doesn't fall in the units, my lord.
Why?
This only in respect of the, my lord, factories.
You mean to say that in this Namru 1, 2 and 3rd unit, this school is not part of that those units?
School is not part of the, my lord, those factories, my lord, those units. And the schools were run, my lord, even now it is, it's run, my lord, as social responsibility, corporate social responsibility.
File your affidavit in this case.
My lord.
File your affidavit. That these school doesn't fall in this Namru 1, 2nd or 3rd unit of this Hindustan Fertilizer Corporation Limited. File an affidavit, we'll seek that as.
My lord, may I pray that, my lord, the matter may be admitted because, my lord, they have issued us letter for contempt, my lord.
Send them. Yes.
My lordship can come to page 39 of the appeal,
39 of?
the appeal, writ appeal,
কোনটো appeal? কোনটো appeal?
writ appeal.
বুঝছো, red appeal তিনটা আছে, কোনটো?
আমার item 17.
17.
39. Item number?
Item 17, my lord, in my case.
Yes.
Yeah.
39, yeah.
Yes. Then lordship will kindly come to next page, 40.
40.
They told all the employees and school you will find, lordship will find principal, then total 117 teachers. Then management employees, management services. School is also branch matter. And at page 39, matter, it is already mentioned, matter. Further to our telex number so and so dated 16/9/1991 and 17/9/1991. Enclosed, please find the summary of the revised sanction post in respect of your unit, department wise, for your record and necessary action. As per board decision, post at the level of APO and above have been classified as corporate level post. 5+4 of the SFCL, General Condition of Service Regulation 1991. Accordingly, while sending the manpower return position of APO and equivalent and above may be reflected in a separate column. You may now initiate promotion of action in respect of the unionized categories as well as the officers below corporate level, posts as mentioned above.
We understand, sir, but now they have come with this order of this Appellate Authority for Industrial and Financial Reconstruction, New Delhi.
Yes,
Therein,
yes,
they have simply said, sir, we are approving the demerger of Namdu first, second, and third
yes,
into the separate company in the name of so and so forth.
yes.
Now they are claiming that this is
They are believing that-
fall
Yes.
under this either of the units 1 to 3. Let them file their reply. And then we'll ask for your, if you want to clarify or if you want to contest that, contest it, we'll consider it.
And my lord, also in the first board meeting, after the merger in 2002, the division parts, may I read, my lord? What only one copy of it.
It is on record.
It's not on record.
No,
That may be
we
also on
got
record.
from the company.
If place it on record, we'll consider it.
After filing of our affidavit, let them file their reply probably, and they can bring this on record.
You file a reply in your counter.
Yes, my lord. Let it come, because the employees are now on the birth of retirement, having served more than 30 years. Let it be-
If we
next-
have to
next week,
decide, then we have to be clarified by the, on that.
Yes. Let them file matter, we'll also file immediately within 2 days.
It will grant the opportunity.
My lord, only one thing. I'm in item number 16, my lord, your lordship will find. My learned friend has said it is not in number of units. But if your lordship look at page 55 of the item 16, your lordship will find there is a number of units.
Sir, here they have bifurcated in this 3 units, 1, 2, and 3. This is what the order of the.
Right. Very correct.
Let them file a affidavit that this school doesn't fall into all any of the units. Consider it, and if you find a counter, we'll decide it, sir.
Your lordship will give a short time. Because already they have taken enough.
My lord, for the first time, they are taking this plea. For the first time.
Not first time, sir. This court on 17/7/2024 asked them to clarify the
Yes.
situation. That's why only in the.
Not before the single bench are able.
Okay. This court on 17/7/2024. Appellants to satisfy. Yes. These writ appeals are being preferred on behalf of the appellants being agreed with the impugned orders passed by the learned single judge, whereby the appellants are directed to regularize the services of teachers working in the Brahmaputra
Valley
Valley
fertilizer.
Fertilizer Corporation Higher Secondary School from last 30 years. The council for the appellants are challenging, the appellants are claiming that the school, the liability of the aforesaid school was not fastened upon the appellant corporation. And this court, by the order dated 17/7/2024, has granted time to the appellant to satisfy that the liability of the school run by the HFCL Hindustan Fertilizer Corporation Limited was not fastened upon the appellant corporation. Lanet, counsel appearing for the appellants has placed on record an order dated 26/4/2002 passed by the Appellate Authority for Industrial and Financial Reconstruction, New Delhi, and has contended that the appellant company has taken over only the Namru first, second, and third units of the Hindustan Fertilizer Corporation Limited on its merger. It is contended that the school in question was not falling in either of the units which were taken over by the appellant company. Stop. Learned counsel for the appellant is directed to file an affidavit of this effect by the next date of hearing, along with the documentary evidence that the school, that the liability of the school was not fastened upon it. Full stop. The copy of the said affidavit will be supplied to the counsel for the respondents. The said affidavit will be filed within a period of 3 weeks. The copy of the said affidavit will be supplied who may file their response if desired so within a period of within further 2 weeks. Next after date 5 weeks ke baad based on so and so.
My lord, can it be so, my lord? Can it let them file within 2 weeks, my lord? We'll file within 1 week. Let me start with
The vacations are coming.
vacations.
within 2 weeks.
That will pass off, my
What
lord.
will be the purpose of that?
In 2 weeks, the vacation will pass off.
In the meantime, the effect and operation of the impugned order, whereby the learned single judges directed the appellant company to regularize the services of the teachers working in the concerned school, shall remain stayed till next date.
Can it one in the first week of January, my lord?
Sir, if you are insisting on contempt, then we have to once if the matter is there.
No, yeah, since your
we are-
lordship
we
is
are
saying it,
considering that, then at least it's now, simply it's a limited. You satisfy us on the next date, we'll vacate that order or will not continue that order. What's the problem?
but that's so, my lord. Since your lordship is already stayed the order, it will be first week of January, my lord. Any 7, 8.
Please.
29 January.
Please furnish today, my lord, maybe given.
So they are filing, we have directed them to file an additional affidavit along with the documents. Within a period of 3 weeks and they'll supply you in advance.
Item 19.
Same man, 19, no, this is another thing, sorry. Filed an application for condonation of delay?
Yes, it was filed, it was condoned, my lord.
Where is that? Right?
It was IA number 362023. It was condoned by the order dated 9/9/24, my lord. This appeal is against the order dated 12/5, my lord.
So that this manufacturer is not able to pay the excise duty. This is what the London single judge has said
My lord,
to us.
my lord, rule 35, my lord. There is a rule, standard credit rules, my lord. Rules 3A says, my lord, whenever scrap is cleared from the manufacturer's factory, my lord, then excise duty is leviable, my lord. Accordingly, we have charged the excise duty, my lord, and we have deposited with the government, my lord.
Rule
3A, my lord. 35A, my lord.
We capital A,
Capital A, my lord.
yes. V5A.
My lord.
Yes.
I will. Three, 5A sub rule B, my lord.
Yeah. Yes, sub rule B.
My lord. If capital goods are cleared as waste and scrap, the manufacturer shall pay an amount equal to the duty leviable on transaction value, my lord. So, my lord, it is an indirect tax, my lord. So we have to collect from the purchaser, customer, and deposit in the government account, my lord. So we have, my lord, we have collected tax from the respondent number 1, and we are depositing in the government account, my lord. Even if your lordship holds that excise is not leviable on the excise and the scrap goods, my lord. In that even, my lord, the amount is lying with the respondent number 2. Because during the pendency of writ petition, my lord, tax was collected and was deposited to the government, my lord. And the writ petition's claim is that tax was of 7 lakhs and odd, my lord. But it was 3,99,000. In the due course, my lord, we have collected 3,99,000 and we have deposited to the government of India, my lord. So even if it is refundable, it is respondent number 2, they will refund, my lord.
From where we got it that you have deposited with the government of India,
Now, page 78, my lord.
78.
Page 78, my lord. And 79 is the list, my lord, against whom we have deposited, my lord.
Page 78.
78 is the challan and 79, my lord, is the list against whom we have deposited this amount. This, my lord, respondent number 1 is the serial number 6, my lord. Iqbal Singh. The amount is 3,99,849, my lord.
Then how this amount goes to 7 lakh and something?
Initially, my lord, when writ petition was filed, my lord, he was supposed to lift 500 metric tons of scrap, my lord. So during the pendency of writ petition, he has not lifted this amount, my lord. He has lifted only 257 metric ton, my lord. On that amount, we have collected this amount and we have deposited with the government, my lord. That, my lord, calculation I have given, my lord, at page 9 of my appeal memo, my lord. These things he has not brought on record, my lord, during the pendency of writ petition, my lord.
Who has not brought on record?
Writ petitioner, my lord. He has not brought.
You have not brought on record, I believe those things.
In the review, my lord, in the review I have brought, my lord. My lord. Page 9 is the calculation I have given, my lord.
One thing is clear that this is to be paid by the manufacturer.
But it has to be collected from the, since it is indirect tax, my lord, it has to be collected from the customer, my lord. And my, I am not a beneficiary, I have collected, I have deposited, my lord. It is not lying with us, my lord. And my lord, in the review petition, my lord, the respondent number 2 has filed a affidavit in opposition, my lord. In that affidavit, they have said it can be refunded also. Lord, you will see it there. Lord's respondent number 2, my lord, in the review petition, they have filed a affidavit in opposition, my lord.
What they have said?
They have said that, my lord, page 83 is there, my lord, paragraph 6.
What they have said?
But they have said that, my lord, may I read, my lord?
Yeah.
That your answering opposite party begs to submit that as per Rule 35AB of Select Credit Rules 2004, quoted above, the charging of duty on clearance of capital good as waste and scrap is just and proper. As such, question of refund of duty does not arise. Now it is respondent number 2, my lord, who is saying.
Respondent number 2 is CGS.
Yes, my lord.
The end of the department is very clear.
Yeah.
Yes, what my management has stated, that in review petition, department has filed their affidavit. And stated that your party beg to submit that as per Rule 35AB.
So what they are saying that it's an indirect test and they have to
Yes, Lordship.
collect it from the consumer and then to pass it to the government. They have already deposited.
That is proper and as per law.
So whatever the this order of refund is there, it has to be paid by the, even if it is admitted that the amount is refundable, then it is also to be paid by the government only because the money is like
In that case, Lordship, if Lordship directs, then we have no option, we have to return. If it is not, if court directs the department, then it can be refunded. But learned single judge directed the
concept. appellant has submitted that the learned single judges, the learned single judge by improving order dated 12/5/2015 has illegally ordered to the appellants to refund the excise duty amount to the respondent Iqbal Singh. And it council has submitted that as per the Senate Credit Rules 2004, the excise duty was deposited. The excise, as per the Senate Credit Rules 2004, the tax imposed on the scrap, waste and scrap is an indirect tax, is an indirect tax and is to be collected by the manufacturer from the purchaser,
consumer.
from the consumer, and thereafter to deposit the same with the Central Excise Department. It is submitted that, as a matter of fact, the appellants have collected the said indirect tax to the tune of rupees 3,99,849 from the respondent Iqbal Singh and has deposited with the Central Excise Department. It is submitted that the said amount is still lying with the Central Excise Department, and even if the same is to be refunded, and even if it is to be refunded, let's say it is to be refunded, then it can only be refunded by the department. Stop. Issue notice, Mr. Kyle put in appearance on behalf of the respondent.
Number 2.
Respondent number 2. Let notices be issued to the respondent number 1 only. Returnable. Let notice be to post and daily, returnable on in the month of February, you did this, returnable on so and so. In the meantime, the direction given by the learned single judge, the impugned order dated 12/5/2015 of the direction given by the learned single judge to the appellants in the impugned order dated 12/5/2015 to refund the amount of rupees 7,54,700 to the respondent Iqbal Singh shall remain state.
There is a small correction. They have made the principal commissioner Guwahati as a party, but it should be Dibrugarh.
They have made the,
In place of Guwahati, it should be Dibrugarh. Principal commissioner CGST Dibrugarh.
they have not named anything.
Yes, Lordship.
Yes, the department in the
No, they have made Central says Guwahati as a party. But the response is to be come from Dibrugarh commissioner.
Is it this in this
Post site.
respondent number 2 address?
Lordship.
It's okay. You are appearing for that now.
No, Lordship.
Either Dibrugarh or Guwahati.
No, the office are separate, Lord.
5th of February. Item 21.
Read appeal, Your Honor, assailing an order on a single judge was in connection with petition number 3620 2022 dated
Yes,
There are, on 2 points, Your Honor, the read petition was filed. That was regarding the guidelines which will be followed and must have been followed regarding merit and seniority. That is one. The other is the locality. My client has both the requirements and the criteria has fully fulfilled, and that has been supported by the affidavit filed by the respondents, state respondents. Your Honor, if any tampering, I don't know whether that was happened or not, if any tampering was there, which could be apparently seen, then that must have to be confirmed by notice, issue notice to the concerned department, whether such tampering was there or not by those persons involved in the selection process, Your Honor.
Okay.
I don't have anything to do with that particular thing. I am only a Anganwadi worker, which is appointed very freshly after fulfilling all the requirements. And Your Honor, the other party, the petitioner, she was a compartmentalist. It is HSLC may not be passed, I don't know, because in this particular set of documents, I have not find any documents to justify that.
You are the best suitable person.
Yes, Your Honor.
So why you are afraid? Then the court has simply said again, do the exercise again.
Your Honor, I'm not afraid, Your Honor.
So then
the thing is that my service has been terminated without giving me an opportunity.
Where is which opportunity?
Your Honor, at least to submit whether I am the suitable person or not.
You are not present before the. You are not represented through consent before the.
I didn't have any knowledge regarding that, Your Honor.
Huh?
I didn't have any knowledge regarding that any case was pending against me.
So this
so I have filed.
Served upon you.
Pardon?
Notice was not served upon the appellant.
Yes, yeah. The notice was deemed served, Your Honor. I don't have.
What do you mean by deemed served?
Yeah, that is rebuttable, Your Honor.
Huh?
That is rebuttable.
What do you mean by rebuttable?
That means, Your Honor, deemed served means I may not.
How the notices were served upon you to register any dusty or what happened?
I don't have any knowledge regarding.
Find out.
Yes,
If you
in
are
the
saying
Lozima
that the
code,
notices have not
Your
been
Honor,
served,
I have annexed a document from the Lozima code that it is deemed served.
Deemed service, where is that? Which are those documents?
Annexer D, Your Honor, 61 to 64. Page number 61 to 64, Your Honor. It may be deemed served, Your Honor.
Deemed service on what basis, sir? Deemed service, we understand. We often not release the input to the respond register post ID, but neither any contract. The meaning of the post page and the indicate the registered notice issued to the was prepaid and properly addressed to the correcting quota, so that deemed to be affected. The section 27 of the.
Sir, in my home, Your Honor, I have my husband who is a daily labor, Your Honor. He doesn't know whether sign or not, whether to sign or not. And I was in the school, then who received it, Your Honor?
Even though if you, suppose if you appear before the learned singer, you should have been heard. And if you did appear before the learned singer, then what was your argument?
Your Honor, what was the?
We are granting you the opportunity of hearing, you satisfy us.
Your Honor, regarding that tampering part, Your Honor, whether I have to do anything regarding that?
But there was
So,
tampering.
what was the tampering, Your Honor? What was the tampering?
The tampering.
I don't have any knowledge regarding the
is that
tampering.
they mark the comments or remarks given to the respondent number 5 as excellent, they were engaged. And it was now set good something else.
Database authority they can do that, Your Honor.
They can do that, and on the basis of you have been selected.
Yes, Your Honor. So who is the best person to answer that particular person, whether why they have done that?
That's why only the learned single judge has taken note of that and said, okay, there is something fishy.
At least the honorable court, single judge court, issue notice to that particular person whether you have make this or not.
The argument is
yes. Yeah.
Okay, fine. That's all.
Yes, sir.
This writ appeal is filed by appellant being agreed with the order dated 3620, the order dated 7/6/2024 passed by the learned single judge in writ petition number 360/2022. The above referred petition was filed by the by one Mofida Atun. Respondent number. Respondent number 5 herein challenging the selection of the appellant as a Anganwadi worker under Babani ICDS project. Stop. The respondent Mokita Khatun has challenged the selection of the respondent number 5 on various grounds. However, during the course of hearing, the learned, the course of hearing, learned single judge has perused the selection record produced by the state, produced by the government advocate, and has found certain discrepancies in the said record. Stop. The discrepancies noted by the learned single judge in the impugned judgment are reproduced here under. Okay. Page number this. These are 1, 2, Yes, six. Okay. After observing the same, the learned single judge was of the view that the selection of the appellant as the body worker is vitiated by apparent tempering of the comparative statement. And the learned single judges further observed that the tempering has been done to favor the candidature of the appellant. Stop. While observing this, the learned single judges set aside the selection of the appellant as Anganwadi worker of the aforesaid Anganwadi center and directed the respondents directed the respondents directed the director of social welfare, Assam and district social welfare officer of the concerned area to conduct a fresh selection for filling the post of Anganwadi worker at the concerned Anganwadi center. Full stop. Learned concept for the appellant has assailed the impugned order passed by the learned single judge. Firstly, on the ground that the appellant that the notice of the writ petition has not been served upon the appellant and no opportunity of hearing was granted to the appellant to present her case before the learned single judge. Would stop. It is also submitted that even if the learned single judges found some tempering in the selection record, the best course for the learned single judge was to issue notices to the persons who were responsible for the said tempering to show cause that under what circumstances the said tempering was done without issuing show cause notice to those persons. The learned single judge has added taken upon itself to come to the conclusion that since there was a tempering and therefore the selection process is vitiated. Learned counsel for the appellant has therefore submitted that the impugned order passed by the learned single judge is not liable to be sustained and is liable to be set aside. Third, learned counsel for the appellant and peruse the material available on record. Full stop. So far as regarding the contention of the appellant to the effect that the notices upon the respondent upon the concept of the so far as the contention of the concept of the appellant that the notices of the writ petition has not been served upon her is concerned, we have taken note of the proceedings of the Lauzima court dated 14/9/2022, wherein it is specifically mentioned that the registered notice issued to the appellant on 4/6/2022 was prepaid and properly addressed with the correct PIN code, and therefore the service of notice upon the appellant deemed to be affected. We don't find any illegality in the said note of the Lazima Court. And it has rightly treated the service of notice upon the respondent as complete, upon the appellant as complete, full stop, be that as it may. Once the learned single judge has found serious discrepancies in the selection process while exercising equitable jurisdiction, if a direction is issued to take a fresh exercise for selection of Anganwadi worker on the concern Anganwadi on the concern Anganwadi center, the said action is not liable to be interfered with while exercising, is not liable to be interfered with. So, in the above facts and circumstances of the case, we don't find any reason to interfere with the order impugned, hence this writ appeal is dismissed.
All right.
Item 22.
Make your law. Not in terms of the judgment dated 6/10/2015 in WBC number 1667 of 2014, they're entitled to back wages. Now, issue is, my lord, whether there's a requirement to comply with the mandate of FR.
Gainful employment.
Yes, FR 54A5. Now, my lord, the tribunal, my lord, the Supreme Court judgments also say that the initial burden is upon the employee. If they discharge, now in this case, what happened? They initially filed an undertaking affidavit which was withdrawn. Now, kindly look at the undertaking, my lord, whether it will suffice for the purpose of the relevant rule at page 105. This is what was given. Page 105.
Yes.
This is to certify that undersigned during period from 14th of July to 2006 to 8th of October 2015, from the date of issue of removal order from HUDCO till reinstatement at service have not been employed anywhere. This is issued to HRW wing HUDCO to enable release of consequential benefits for the above period as per order of the Guwahati High Court. And the requirement is there has to be an affidavit. Initially, an affidavit was given, subsequently it was withdrawn.
But
I'm relying on two judgments of the Supreme
by whom? This
by the applicant before the tribunal respondent. Yes,
by the employee.
Yes,
This withdrawal, from where we see this withdrawal?
yes. Initially, my lord, if your lordship would kindly come to para 2020, my lord, we have stated the whole thing.
Yes.
Yes. That the petitioner begs to submit that FR 54A5 provides that any payment made as per FR 54A to a government servant on his reinstatement shall be subject to adjustment of the amount. If in para 20 at page 17 of the petition.
Yes, yes.
That the petitioners beg to submit that FR 54A5 provides that any payment made as per FR 54A to a government servant on his retirement shall be subject to adjustment of the amount, if any, earned by him through an employment during the period between the date of dismissal, removal, or compulsory retirement and date of reinstatement. As per FR 54A5, payment made to a government servant after his reinstatement shall be adjusted with the amount earned by the government servant during the period of his dismissal, removal, or compulsory retirement. The Honorable Apex Court in so-and-so has held that the term gainful employment does not include employment in an establishment, but also includes self-employment. Therefore, the word employment as mentioned in FR 54A5 is non-exhaustive and includes a wide range of vocations. However, the respondent in his letter dated 18 to 19 has been evasive in disclosing the factum of his employment, as the said rule mandates that income earned by the respondent during such period must be adjusted for arriving at the amount of the consequential benefit, and such income includes income by of salary, business or vocation in terms of various judgments of the Honorable Apex Court. So my lord, it's and by this letter dated 18 to 19, he indirectly admits that he in fact was in employment. That letter lordships will get at page 138.
18 to 19, he is indirectly admitted. Where is that?
Yes, yes. Page my lord 138.
138.
Yes. If your lordships would kindly come towards the bottom last para, sub-para. In this regard, may I bring it to your kind attention that, I'm sorry, my lord, page 138,
Yes.
the last sub-para. In this regard, may I bring it to your kind attention that there is a contentious issue of signing affidavit which HUDCO HR wing has asked me to sign as per the format suggested by law wing, which is actually meant for officials under suspension from service. However, in case of the undersigned, I was removed from service without giving any financial compensation and means of livelihood provided to take care of my family, and hence I had to find ways and means to sustain myself. So he himself admits that. And there is no affidavit from his side. So tribunal, in my humble view, my lord, would not appreciate the purport of FR 54A5 in proper perspective.
54.
Yes, yes. Fundamental rules from the action. Asan?
Read.
Hobo. Huh? Oh, no. FR 54 capital A subpara 5. Any payment made under this rule to a government servant on his
FR 54.
54 capital A subpara 5 minutes. Pages may not tell you, I'm holding a old book.
Right, any payment.
Yes. Any payment made under this rule to a government servant on his reinstatement shall be subject to adjustment of the amount, if any, earned by him through an employment during the period between date of his dismissal, removal, or compulsory retirement and date of reinstatement. Where the emoluments admissible under this rule are equal to or less than those earned during the employment elsewhere, nothing shall be paid to the government servant. So this is the mandate.
You mean to say that on that purpose, he has to file an affidavit?
Yes. Well, in fact, there are two judgments of the Supreme Court stateway on this point, Miller. Regarding that, 2023 SCC online, SCC 776. Lord, para 8 and 9. Only question before us is whether the labor court was justified in denying relief of back wages.
Yeah.
Only question before us is whether labor court was justified in denying relief of back wages. In the case of National Gandhi Museum versus Sudhir Sharma, this court held that the fact that whether an employee after dismissal from service was gainfully employed is something which is within his special knowledge. Considering the principles incorporated in Section 106 of the Evidence Act, the initial burden is on the employee to come up with the case that he was not gainfully employed after the order of termination. It is a negative burden. However, in what manner the employee can discharge the said burden will depend upon peculiar facts and circumstances of each case. It all depends on the pleadings and evidence on record. Since it is a negative burden, in a given case, assertion on oath by employee that he was unemployed may be sufficient. So if that is on oath, then it may be sufficient. So it's a negative burden. Now Now, coming to the facts of the case, we find that in the state.
Another judgment you were.
Yes, my lord. Another judgment is on the scope of the FR 54, my lord. I can do it now. Right. My lord, here in this case, the employee took a stand that the income which was generated by way of agricultural income. So even Supreme Court said even that will also be included, my lord. Please come to para 17. Citation is 2007 10 SCC 765. Para 17.
7-6.
On the said question, we are unable to accept the reasoning of the labor court that the income received by the respondent from agricultural pursuit could not be equated with income from gainful employment in any establishment. In our view, gainful employment would also include self-employment where from income is generated. Income either from self-employment in an establishment or from self-employment merely differentiates the source from which income is generated, the end use being the same. Since the respondent was earning some amount from his agricultural pursuit to maintain himself, labor court was not justified in holding that merely because respondent was receiving agricultural income, he could not be treated to be engaged in gainful employment. Para 20. In view of what we have stated herein above regarding the income received by the respondent for the period of his dismissal from service till the date of award, we are of the view that award passed by the tribunal after remand and affirmed by the High Court, both by the learned single judge and division bench, is liable to be modified, and earlier award of labor court is liable to be restored. In para 22, in the event full back wages from the date of dismissal till the date of award has already been paid to the respondent, the appellant corporation will be entitled to recover the same from the employer. So, my lord, law appears to be well settled. There is a yes. There is a
Earlier he has filed an affidavit and that has been
withdrawn.
Where is that?
Yes, my lord. Undertaking, huh? So, my lord, undertaking was given, which was withdrawn. Undertaking, I have already referred to it, page 105, my lord. Notice, 135.
My lord, undertaking was not withdrawn.
No, affidavit এখন উদ্যোগ করছে তোমার পাইছো না। কোনো পাইছো না? হ্যাঁ? Oh, no, no. Affidavit দিছিল না। I'm sorry, my lord. I got here in this case an undertaking was given, which was not withdrawn. Affidavit withdrawal is in the facts of the other case. I'm sorry, my lord. Here, my lord, there is no affidavit. And my lord, the learned tribunal could not have wished away the requirement envisaged by 54A. Some opinion of the my lord additional solicitor was also brought on record, where it said that there is no requirement of affidavit. But then, my lord, that's an opinion, but the Supreme Court judgment speaks otherwise.
But judgment also doesn't say that in every case.
Yes.
It has to be in given case.
No, my lord, here in this case, no, here,
Given case.
no, normal law is, my lord, normal law is, it's something like, my lord, it is not within the knowledge of the employer. That is the reason. It is, my lord, the same principle as enunciated in 106 of the Evidence Act. Otherwise, normally under 101 and 102 of the Evidence Act, it is the duty of the plaintiff to prove this case. But something which is not within the knowledge of the employer, my lord, that employer cannot prove. It can be proved by the employee only. That is why the principle of 106 was brought in. সেইটো বাদ দি পেলাই যিটো ইনকাম সি আৰ্ণ কৰিব সেইটো এডজাষ্ট কৰিব সি দিব সেইটোৱে If your lordship would kindly come to page 19, my lord, our averment, page 19 on top. After referring to that letter dated 18 to 19, therefore, in order to ensure that respondent was not gainfully employed as claimed by him during the period of removal from service till his reinstatement, petitioners had requested respondent to submit an affidavit regarding the same in the format provided by the petitioners. However, for reasons unknown to the petitioners, the respondent has refused to submit the same.
Yes. Not the judgment cited are of the labor and the industrial cases which have come from the labor court. There is not a single judgment of the Supreme Court interpreting, my lord, FRA 5 and its scope. So far as tribunal is concerned, my lord, tribunal looked into.
General.
My lord, it's a general principle, my lord, but my lord.
Whether this employee was gainfully employed or not, it is certainly a fact which is in his knowledge.
Yes.
Yes, you do file an undertaking.
Yes.
That I was not employed or gainfully employed anywhere. But when, for the purpose of ascertaining themselves, if they have asked you to furnish an affidavit, why you refuse to file an affidavit?
My lord, may I put it this way?
Yeah.
Here is a case wherein the petitioner was removed from service. My lord, once there is a removal from service, there is a breaking of legal relationship. The vinculum juris breaks down completely. And my lord, any individual, certainly my lord, is not expected to beg by the roadside. He has to sustain himself. So my lord, once my lord,
you simply you could have said, I had no income and I was so and so income only. This much of income I was having, and on
That will be adjusted.
very meager amount I was sustaining myself.
my lord, therein lies a catch. Therein lies a catch, my lord. The answer is, my lord, I'll put it this way. Whether, my lord, any income generated during the period when there was no legal relationship between the employer and the employee, my lord, because there is a purpose.
So then if there was no relationship between the employee and this employer, then certainly another logic would be that there is no relationship between the employer and the employee during the course of termination. Where is the question of back wages?
My lord, to this, my lord, the answer would be, my lord, to this, my lord, there is another proposition, my lord, may I? To this, there is another principle in the proposition. If the order of removal or dismissal from service is expressly illegal, and because of the conduct of the employer, I was restrained and prevented from working, then in that case, so, my lord, there are judgments also on that line. My lord, may I also, my lord, may I?
Where the employee was illegally, services are illegally terminated.
This is what the finding of the High Court is.
Entitled for back wages, certainly, or all the other consequential
Yes, my lord.
benefit which he is entitled to or she is
Yes.
entitled to.
Yes.
But at the same time, whether this employer has no right to ask you whether or to ask you to give information whether you have been gainfully employed or not. That's all.
This information is given by way of an undertaking, my lord, and may I also, my lord,
But
may I also.
if they have asked for this, okay, please give us a affidavit in this respect. Suppose tomorrow a fact come to their knowledge that you're earning from so and so source, then certainly affidavit binds a person for that. It's a statement on oath.
Then, my lord, the question would be again, the question of adjustment would arise. They would like to adjust. So here, my lord,
That may be.
My lord, I seek my lord's indulgence.
Also, adjustment, then they are not entitled for any adjustment.
My lord,
I'll
make my submission. My lord, I'll make my submission on this. My lord, I'll put it this way.
And that's why only
the tribunal, my lord.
That's why only this 54 says, okay, if that amount is equal to or more than that, then he's not required to pay anything.
Lord, I'll just make my submission. Lord, may I put it? Look, Lord, it's like this. The tribunal, Lord, I'm sorry, I'll make my submission. Lord, the tribunal has interpreted FR 54 capital A1 and 54 FR 54 capital A3. The tribunal has come to the conclusion that the case of the the case of the private respondent herein falls within FR 54 capital A1 and FR 54 capital A3. And therefore, FR 54 A5 is not attracted.
Let us go. 54.
Yes. 54 A1.
A1. Yeah.
This I read, where the dismissal, removal or compulsory retirement of a government servant is set aside by a court of law, and such government servant is reinstated without holding any further inquiry. The period of absence from duty shall be regularized, and the government servant shall be paid and allowance in accordance with the provisions of sub-rule 2 or 3, subject to the directions, if any, of the court. So, Milord, is totally, and here the Honorable Court said, reinstated with all consequential benefits. The competent authority of HUDCO was also not required to pass the order of reinstatement. The private respondent was reinstated by the order of the Honorable High Court. SLP against the order of the Honorable High Court was dismissed in limine. This issue was never raised before the Supreme Court. And Milord, the Honorable Tribunal also interpreted FR 54A3.
Yeah,
this also I read, if the dismissal, removal, or compulsory retirement of a government servant is set aside by the court on the merits of the case, here it was on the merits of the case, period intervening between the date of dismissal, removal, or compulsory retirement, as the case may be, and the date of reinstatement shall be treated as duty for all purposes. So, as ipso facto, it follows. It's a necessary consequence. This is what FR says. And he shall be paid the full pay and allowances for the period to which he would have been entitled had he not been dismissed, removed, or compulsory retired or suspended prior to such dismissal, removal, or compulsory retirement, as the case may be. It's mandatory shall, my lord. And here it was on merit. The Honorable Court found that the order of this removal was ex facie illegal. It would need some deliberation, my lord. It's an interesting question.
That's right, but sir, what you are suggesting that this 54A1 and 3, these rules can't be read in isolation.
Exactly.
It has to be read the whole.
That's why, my lord, I submit. My lord, I concede to the fact that my esteemed colleague has raised a point of law. It would need a degree of deliberation. My lord, my only submission would be, private respondent is now 70 years old, some short date, my lord. I also came late at night. I will do some research, I'll bring the case laws.
Sure, no problem. Concept of the
Short date, my lord, only.
sure, sir.
And we would not press for contempt. So, my lord, don't stay, at least will not find. I understand.
That may be recorded, Mill.
Yes, yes.
Then concept of the petitioner is submitted. Has failed to take into consideration. The respondent has failed to discharge his burden that during the time when he was dismissed, he was out of service on account of his dismissal. He was not gainfully employed. So it is submitted that though an undertaking was given by the learned, by the respondent before the tribunal on 6/5/2018 that he have not been employed anywhere. However, when the petitioners have requested the respondent to file an affidavit of this effect, he refused to do the same. And
25
this fact itself is clear that the petitioner has not fully discharged that the respondent has not fully discharged his burden that during the period when he was out of service on account of his removal was not gainfully employed. Full stop. It is submitted that this aspect has not been taken into consideration by the tribunal. Per contra, the net counsel appearing for the respondent has supported the impugned judgment passed by the tribunal and has submitted that as per FR 51, capital A 1 and 3, in the case of removal, the government employee or the employee is entitled for full back wages and full back wages, and the question of gainful employment will not arise, would not arise, would stop. Having heard the learned counsel for the parties, we are of the view that matter requires consideration and admit no need to issue notices. Parties are at the respondent. Who is appearing for the Union of India?
We can serve copy on Mr. R.K.D. Chaudhary Miller.
Admit is the proper notice. The counsel for the respondent number 1 is represented through counsel. However, the notice of the notice to the respondent number 2, Union of India, be served upon the standing counsel of the Union of India. No need to issue formal notice. List this matter for hearing in the month of.
I'm at my lord's disposal.
February 1st week.
Yes. Yes.
So the date up.
Miller.
From so and so.
Any date convenient to my friend.
Learned counsel for the.
Because
ongoing. Yes.
Learned counsel for the respondent have assured this court that the respondent number 1 will not initiate contempt proceedings. Yes, complaining about the non-compliance of the order passed by the charge.
Deep left.
4th of February.
Yes.
Item 25.
Please, your lordship, matter may be adjourned for the day, lordship.
Why, ma'am?
My senior is a court number 3 and
Then it will come in January.
lordship fix before vacation, any date.
Before vacation. Yes.
Item 26.
What remains in this matter now?
That's not matter. I've been told that my lord, nothing remained, my lord.
Yeah.
My lord. He actually, my lord.
Now you appeared in the examination that selection is already over. All the persons have already been appointed. What remains?
But I have alleged the anomalies, my lord, because in a selection process, my lord, where 92 questions, my lord, incorrect questions are there, and 52 grace
Whether
marks.
it can be reopened, sir, then you have to make all those persons selected as party respondent would be, you will be able
But
to
their
do
name never been declared, my lord.
that. Huh?
Their name never been declared by the
Rule number very.
examination. my
Which one? Which?
98 candidate that
No,
those
number
who are
very.
undeserving candidate, my lord, those who
Yes.
are in the,
That the names have not been declared.
no, not been declared.
That
my
has been declared in another proceeding before this court.
Yes, yes. In fact, that was
The whole exercise was there and everything was done. But what we are saying now, what you will gain out of it, sir? You appeared in the main examination.
I appeared in main, my lord.
And
I did not
you
qualify.
failed to clear that.
Yes.
Well, once you took a chance, your name figured in both the answer, this result published.
No, my lord. No. In preliminary, he, my lord, let me say, he preliminary, he passed, my lord. Preliminary, he passed. Then he preliminary, he appeared in
initial stage or?
No, no, in all states, he is there, my lord.
Okay.
Then he appeared in,
Twice the result was published and in both the
my lord, no,
results.
my lord, he was in there, then he appeared in final examination, my lord.
Okay.
After final exam, when result was about to declare, and that point, after 9 months, he is challenging the preliminary result, my lord. That is the case, my lord.
Once without raising any grievance about this
In both the
preliminary
he appeared.
examination result, if you appeared in the main examination, what appears? What remains?
But we are that there is no cutoff marks, my lord. That is the mandatory on the part of the authority
Now
to.
the selections are over since long.
Then
Appointments were made, I think so, in 2020 or 21.
22, I think.
No, that was 28, my lord. And that is 18, my lord, 2018.
Pursuant to this selection, appointments were given to the selected candidates when?
Selected candidate, they were appointed in 2021.
2021.
21 January.
4 years have passed. How can we examine all those things?
No, his writ petition was dismissed on the ground of non-joiner of necessary party only.
Two ground, my lord, on the ground of non-general necessary parties, and this, my lord, that estoppel, my lord.
Certainly, learned single judges appear to be right.
But I have a judgment, my lord, which says that, my lord, in case of somebody, there is illegality in the selection process, my lord, then estoppel will not come, my lord.
Not in every case. In given case, it's okay. Surely, and now it would be very difficult to again recall all those things. There was a mess on the part of the APSC.
There is absolutely, my lord. There is no doubt about that.
But
Lordship will found it in their affidavit, my lord. They have admitted the position. Affidavit.
Sir, in fact, we have gone through all these things by dealing with.
I know, my lord. That just
Today morning,
today morning, my lord.
I'm questioning you. All these facts they have taken into consideration and they have created a mess. On account of that, many persons have suffered. It's okay.
That is in their affidavit, my lord. The para 6, they have admitted that the wrong committed by them.
Out of these 98, whatever the persons, only 4 have been selected.
Yes.
Ultimately.
6,
Only
my lord.
4.
6.
4.
4
4 plus 2.
Two are the persons who never cleared this preliminary examination. Their names were not there in the first or second list.
My lord.
Their names were not there. Only 4 persons have cleared this. Even though if your grievance was this that 98 persons were wrongly allowed, only out of them 98, 4 have been selected ultimately.
That is correct, my lord.
So, how it matters?
I want to show that para 6 of their affidavit, my lord.
Sir, we admit.
Understood.
We admit, but
Lordship.
by this writ appeal, the petitioner. The petitioner or petitioners?
Only one.
Petitioner has challenged the order dated 2020 by the learned single judge in the writ petition number 2587/2020, whereby the learned single judge dismissed the writ petition. The appellant has approached the writ court the selection process of the combined competitive examination 2018 conducted by the Assam Public Service Commission. The appellant has claimed that several irregularities have been committed by the APSC while conducting CCE examination, CCE, the Combined Competitive Examination 2018. And on account of that, the whole selection process is initiated. Full stop. Para. And then single judge has non-suited the appellant on the ground that on the ground that after declaration of the result of the preliminary examination, the petitioner, the appellant has not challenged has not questioned the process of selection conducted by the APSC and has been chosen to appear in the further stage of the examination, that is written examination. And in single judge has observed that when the appellant has failed to clear the written examination and has failed to get a favorable result, he turned around and has challenged the selection process on the ground of illegalities committed by APSC. The learned single judge has observed that such a course is not permissible, and therefore the petitioner and therefore no relief can be granted to the appellant. Full stop. The learned single judge has also observed that the appellant has failed to implead those persons as party respondent who have cleared the CCE examination, the CCE 2018, and in the absence of the selected candidates as party respondent, the relief prayed for by the appellant cannot be granted. Stop. Having gone through, having heard the learned counsel for the appellant and after going through the material available on record, we are of the view that the findings of the learned single judge in the facts and circumstances of the case cannot be said to be illegal or unreasonable. Full stop. Otherwise, also the selection process pursuant to the CCE 2018 has already been completed, and the selected persons have also been provided appointment on the
January 2021.
the appointment in January
2021.
January 2021. And on this ground also, we are of the view that the challenge of the appellant to the judgment of to the improved order passed by the learned single judge, as well as the action as well as the process of examination of CCE 2018 is not liable to be entertained, hence the select appeal is dismissed.
Only thing, one factual mistake, my lord, that he is challenged after, my lord, preliminary exam, final examination given, my lord, not before the result, my lord.
I wouldn't get it.
Because his result was declared subsequently, my lord, but before that he challenged the this selection process.
Preliminary examination results
Declared, before final result declared, my lord.
Final result, we have simply said that immediately before the preliminary examination, you are not challenged. That's why only. This is what we have said. This IA is also disposed of whatever the IAs are.
Item 28.
Lordship, in this case, I am appealing for the respondent. Some time may be granted to file affidavit, Lordship.
We have also filed.
For the respondent place some time to file counter to the red petition. Time for is not.
My lord, an additional affidavit is filed yesterday, my lord. That may be not on record.
So that will be taken. Yes.
Item 29 and 30.
29, in the morning, I had made a mention. Wakalatnama is yet to be received, so I cannot make any.
No, Melata, I spoke with the lawyer's concerns.
No,
that is fine. So
Both these matters are tag matter, Lord.
So now you have forgiven You have forgiven him.
No.
You were raising, yes, your concern was genuine. But you should have, even though if you have, in that case, you are not, once you should have informed the party.
No, Milord,
He was in.
Milord, there is some confusion. My learned friend is, I will not now get into that. But the point is that the instructions were that our matter can go on, that they were not to take in, that they were just to say that. So I spoke with their lawyer. Anyway, Milord, there's only one request I have to your lordships today. In the item 30, your lordships may have the file. May I hand over the order dated 1st of October, Milord?
1st of October.
Yes, 1st of October.
Item 30.
30. Milord, because the issue was eventually, Milord, what has boiled down before the learned single judge is that's a narrow compass, the preservation of the underground springs. And who is to do? Milord, your lordship, if I may read the affidavit, Milord, paragraph 2, the order, Milord. Mr. D. Saikia, the learned advocate general, Assam submitted a joint inspection was carried out by PWD authorities with the CISR, National Geophysical Research Institute, IIT Guwahati from the 5th of September to 7th of September. And thereupon a feasibility survey report and proposal has been submitted by CSIR, National Geophysical Research Institute, and is being looked into by the IIT Guwahati. He further summarized on account of the timeline, certain negotiations are going on as such the agency has not yet been finalized. And therefore, Milord, this is relevant. Paragraph 4. Mr. D. Saikia, learned advocate general, therefore submitted that the matter be listed after 4 weeks so much that a clearer picture can be placed before this court. Now, Milord, my request is that let them file an affidavit and your lordships may have it after.
That near opinion, we have already instructed them. Get the, whatever the issues there in this petition, in this petition filed by this Geetika Bhattacharya and others. We've already instructed the AG and without taking any further consultation, without that, yes.
No, then that has to explain, because this matter has progressed more than the matter has the same than before your lordships, the PI. Because there's a substantive petition and the PI, your lordships jurisdiction is separate. What happened in this matter was because we are also concerned in a narrow scope, the preservation of the springs, but the manner in which the project has happened, and I don't want to, because I will.
Still, they have not started the project.
No, they have not. But my the concern is the contract has been awarded. The contract has been awarded. So what is awaiting now, Milords, is the contract was to commence. Now, if we had not filed the petition before the single judge where the orders came to be passed, so what transpired is that the entire design and consultancy of the project, that was one part, and the award of the construction bid was predicated on in the absence of or consideration of the natural springs. They considered it to be a sculpture. It is only after award of the contract in 15 March 2024, when we approached the learned single judge, that they finally engaged the IIT. No, but in what circumstances? And that is the reasons why the learned single judge was monitoring. Because the engaging of a consultant for the hydrological survey as to how this water will flow was entrusted to the contractor, the successful contractor, L&T, who's already got 400 crores. Then monies was sanctioned to him that he would engage the consultant. Well, there is therefore a fundamental conflict of interest, because if the contract, it would not be. So the whole purpose was that that would be an independent exercise. So then, Milord, what happened was,
this issue was earlier raised.
No, but those pleadings are not before.
Will allow you to speak. This issue was very much raised. And at that time, learned AG has assured us that without getting clean check, that these streams are not going to be affected. We are not going to start the work or will not allow the contractor to start the work. Let them come with the finding. We'll examine it. And if you are not satisfied, certainly we'll issue certain directions.
No, I'm aware of it. But what I want to, if your lordships will bear with me for one more minute. Because therefore the agency, because Milord, today I cannot decide, nobody else can decide, neither the court, Milord, it's the expert who will decide that. The only concern is that the investigation should be independent. Today, so therefore, if IIT was.
If the IIT, you have any doubt in this?
I'm coming to that. This one. IIT was not interested with the monitoring. The money was to be given to, consultant was engaged by the contractor, to whom the contractor was awarded.
So then, whether this court can ask them to engage so and so.
No, Milord, I'm not saying that. No, I'm not saying that. I'm not for a moment saying that.
Then?
Today, the whole purpose is, well, all right, let me put it the other way around. If the contractor who's getting a 400 crore contract if he's engaging a consultant and paying that consultant, then obviously, my lord, there is the independence of that a consultant will be impaired, and which is precisely what happened. The consultant that they engaged was not found to be suitable. That was only because the learned single. I wanted to demonstrate that to your lordship, the various order sheets and the various affidavits which filed before the learned single, because the matter has been gone into some depth. Otherwise, my lord, today I am also aware of the court's jurisdiction, the court limitation. So is the court also aware, my lord. The only purpose is that you have to ensure that the entire process is transparent and the entire process is independent. Yes. So it is
Will not be compromised in any term.
I am grateful.
This, whatever the sanctity of that place is, it can't be compromised. Whatever the contractor, or whatever the state government, or whatever the authority, it can't be compromised in any manner.
Please, I'm extremely grateful. So, my lord, only in terms of them, let them file
Lots of people, certainly we are aware of that.
So, therefore, in terms of that order, let them just file an affidavit in this regard.
But in fact, in the matter, we have filed 2-3 affidavits. We have said that it will not be compromised. Well, the processes are
What
there.
happened? What is the progress?
I'll bring it on record. Malad, the progress in the form of affidavit, I will file it.
What is the progress, Mr.
Malad, it has been taken up with the IIT, with the IIT's final thing is IIT final say is yet to be received.
Final?
IIT's final view.
जोर से बोले.
Malad, IIT's final view is still awaited.
Still, the IIT has not given its views
Final.
or whatever it may be.
Yes.
But what about this issue? This issue raised by the contractor has engaged a consultant, and on the basis of his consultation, that may is at some point that the contractor, if the contractor himself is engaging a consultant, then there is all possibility that he may give a whatever the consultancy as per his choice.
No, consultant has been Malad, proposed by the PWD department, and with the approval of the IIT only it will be finalized. Malad, it is not left to the contractor that he will pick up ABC and then he will do with that. Well, after consultation with the IIT only, because earlier some agency came, but that agency ultimately they have given a proposal. IIT said that is not workable. That
consultant was appointed in consultation with the IIC.
Absolutely.
So it was their consultant. So all they have to do is, Malad, they said this NGRI, because if it is NGRI, it is a reputed body. If it is engaged, so this is all that they have to put on affidavit. That's all I'm seeking, Malad. Let them file an affidavit in terms of your lordship's order.
Mr.
Hazard.
Council appearing for the state has submitted that the state government would file an affidavit in these petitions detailing out the progress took place in the matter. Full stop. He placed some time. When
Well, Lordship give a 4 weeks time after the vacation.
the vacation date. This is a 2024. 25
It was 25 calendar. I think till the 20th there is a holiday. Lordship, let it be on 20th of January.
20th of January.
20th is the reopening then. Agreed. Yes.
Yes.
Item 31. May I please, your lordship?
I am appealing for the respondent, full respondent, lordship. We are not going to file any affidavit in the matter.
Your choice.
Lordship, we are in the impression that he will file the affidavit, lordship. The matter will be heard on another date, lordship.
Yes, you approach the learned single judge against the order of Tribunal.
Yeah, labor code, labor.
Yes.
Labor court. Labor court.
Lordship, my senior will appear later on, Lordship. I'm not ready.
Please request your senior to look into it, that in some of the matters where the learned single judge has adjudicated the award passed by the labor court or industrial tribunal, we have some doubt regarding the maintainability of the writ of appeal. We have fixed the matters on 17th December. Just on 17th of December, we have fixed some matters and be prepared with this.
Yes,
Lordship.
Whether this maintainability part.
It is under section, article 227, Lordship.
Item 22.
With pleasure, Lordship.
This method, Lordship, as per the Honorable Court order, Lordship, we have filed our affidavit, Lordship, bringing the record of revocation of the.
This, you have already refixed.
Yes, Lordship.
My lord, that has been refixed pursuant to the my lord, order of the Honorable Single Judge, my lord.
You have been.
Pursuant to the order of the Honorable Single Judge, which is under change, my lord. But in the meantime, my lord, your lordship directed that it should be refixed so that, my lord, I keep on getting my salary. That, my lord, I am getting. Now, my lord, I had two grievances primarily. Firstly, my lord, I was selected as a peon, but my services are utilized as my lord, the driver. Because, my lord, earlier I was working as driver in a vacancy. Then, my lord, the person against whom the
post against which you were appointed.
Yes. He has come back.
Reinstated.
Yes,
Then
my lord.
suddenly you were demoted.
Yes, my lord.
So
Now,
what's
my lord,
wrong
my
with that?
submission with your lordship is that, my lord, up to, my lord, I was demoted, reverted on 2/5/2014.
Yeah.
So, my lord, firstly, my lord, I wanted to pay protection, perhaps that your lordship, my lord.
It's a question of.
No, but then, my lord, my lord, I have rendered my service as a driver up to, my lord, 2014.
Oh.
Now, from that, my lord, date, I should be getting the, my lord, the salary of peon.
Yeah.
But then, my lord, yes, my lord, but the calculation has been done with effect from 2006, my lord, when I was initially appointed.
Lordship, because
That
he
is the
was
part, my lord,
initially
I am
appointed
agreed.
as peon. He was initially appointed as peon, Lordship.
I was not appointed as a peon.
We are aware of the facts, sir.
Lord.
But the learned single judge has said, okay, he is the entitled for the salary of the driver up to he worked as a driver.
Yes.
And thereafter he will be he is entitled to get the salary of peon.
Yes.
Now, what they have done?
They have done, my lord, they calculated this, my lord, my salary as peon, taking with effect from 2006, my lord.
For what purposes?
For, my lord, giving my salary now, my lord.
No, I don't understand.
If your lordship, my lord, please the, my lord, their calculation, they have started the calculation in the affidavit, my lord.
Sir, you were appointed as a driver when?
On 2006.
2006, and you worked as a driver
Up to, my lord, 2014.
So 2014.
Yes.
So you drawn the salary of a driver from 2006 to 2014.
My lord.
And thereafter, now they have refixed your salary as a peon from 2014.
My lord.
So what's wrong in that?
No, my lord, they have fixed the, my lord, the salary, taking the calculation from, my lord, 2006.
So
As if, my lord, I was a.
So from which date your services to be taken into consideration?
From 2014, my lord.
No. That was 2016, that was a stopgap arrangement. In between whatever you got it.
Yes, my lord.
That has not been to be recovered.
Yes.
That's all. The London single judge has rightly considered each and everything and passed the order, sir.
No, my lord, the honorable single judge, my lord, that is the part I am aggrieved at.
Yes.
Last
Please show us which part you are agreeing.
my lord, the last part, your lordship may kindly come to page 95.
90, para number.
Paragraph 18.
18, yeah.
In view of the discussions made above and for the reasons assigned herein, the repetition stands partly allowed to the extent indicated above. It is clarified that after refixation of the pay scale with effect from 30/10/2006, the pay and allowances resulting from such refixation will have the prospective effect from the date of this order.
Sir, how can, any other order can be passed? How can it be from 2014? Your appointment was against the post of a driver on account of vacancy arose due to dismissal of one of the drivers.
Right.
He was reinstated again, and you have to be put back to that position only.
No.
And whatever the service benefits you are entitled for. That will be.
Because, my lord,
Don't find any merit in it.
if your lordship kindly sees, my lord, the at least one page your lordship see of the affidavit, my lord, the calculation they have made as if, my lord, is 99, your lordship may kindly come, my lord.
Sir, it would mean that as if you have never been appointed as a driver.
Yes.
That would be the case only.
My lord, then the other question arises, my lord. My services has been utilized because of the, my lord, it must be a fault of, my lord, some of the my lord, persons who have appointed me.
Sir, that is not the, sir, it was a coincidence that that person, his services were terminated, you were appointed in his place as a driver, you worked as a driver, but ultimately when he came back, there is only one post. They have to adjust it.
The only aspect,
Adjust you again on that.
only aspect, my lord, that, my lord, the
Admit.
question is that,
Having heard the learned counsel for the party, admit, no need to issue notices, parties are already represented. Just in due course. If you are happy with it, pending पड़ा है तो ठीक है, it's okay.
no, no, I'm getting the salary of peon. Only thing is whether, my lord, I'll get a little more, my lord. That is the only issue because I was used to a particular salary for 17 years, man.
Such type of cases, there are.
More than 10 years, I was used to a
Anything, but at least
particular
you
salary.
to senior people should say, खत्म करो, इसको कोई नया आदमी हो तो उसके पास फाइल रहनी चाहिए ऑफिस में. Why you are worrying about? That cases में there is nothing.
2014 order by which my lord he was reverted back, that was not under challenge, that has been reflected in. Item 34 to 36.
This is regarding settlement of a fishery. There are three appeals, my lord. My appeal is, my lord, item number 35.
Yeah.
My lord, the three appellants, my lord. I had offered the highest, my lord, bid, my lord, 6,51,000 per year. Then, my lord, the other appeals, my lord, 5 lakhs and 4 lakhs. No, I was given the settlement. The question on, my lord, the ground on which my settlement was challenged is that, my lord, the certificate which I used, my lord, to show that we are the actual fishermen, that was, my lord, the language was such that, my lord, we are not actual fishermen. In fact, my lord, my clients are, they are, my lord, self-help group women, my lord.
That wives of that.
Yes, my lord, that is the
Fishermen,
language.
wives of fishermen.
That is, my lord, what the language is. They are only, my lord, wives of the fishermen. They are not actual fishermen. In fact, my lord, subsequently, I have filed an additional affidavit giving a, my lord, correct certificate. That your lordship will get, my lord. The additional.
They ordered in one of the petition. Which
Yes, my lord. In my case, my lord, there is a stay.
I have.
This will be
117.
they are safe. My lord, if your lordship kindly peruses my additional affidavit, starts at page 117. 121 is my lord, the certificate later issued, my lord, which language is also, my lord, somewhere, it is, my lord, correct.
These matters are already admitted.
We have an urgency, Lordship. We are not getting any revenue, Lordship.
What's the urgency, sir?
Because we are not getting any revenue from this.
They're not paying.
No, nobody is running now.
My lord, the honorable single judge directed, my lord, that fresh NIT should be issued.
Last 1.5 years, Lordship.
Yeah.
For the last 1.5 years, around.
Will be taken up for final hearing, some, any day convenient to your lordship.
Lordship, today also, Lordship, it's simple. It is on.
This is by, the one petition is by this Nayan Jyoti self-help group.
Yes, my lord, I am the.
Was the highest bidder.
Yes, ma'am.
And in favor of whom this
Settlement was granted, which was set aside.
And who is this Natun?
Yes, here, Lordship.
Yeah, who are you?
I'm the second highest bidder.
You're the second highest.
My position was that Lordship, settlement was, I was the previous lessee, Lordship. 2013 to 20 was my lease period. There, within that period, Lordship, it was noticed that we could not carry out the fishing activity because of the fish disease, Lordship. So that is why extension was given to us. And during the extension period, what is unfortunate event has happened is the COVID episode has taken place. And again, Lordship, because of the COVID, we could not. And that is why some outstanding was, so that already reflected in the impugned order of settlement while settling that. Otherwise, Lordship, I fulfilled all the criteria.
And who is this Kumar Kabitara? Huh?
I mean, wait for Kumar paper.
Who is he? He is
My lord, he is the responsive bidder.
responsive bidder. Yeah, the L1, L2, L3.
L3, my lord.
L3. Okay. Looking to the fact that at present the fishery is not being operated by
Any part.
any of the three appellants, and the government is losing revenue day by day. We deem it appropriate to raise these matters finally at admission stage itself in the month of January 2000, so and so, list on so and so. Date bata do aap.
Meeting.
Lordship, first week of January, Lordship.
First week,
Whatever the date, you please consult yourself and then come.
First week of January.
30th January, 30.
2 months আগত তো, বিহুৰ আগত তো।
21st January,
Huh?
21st January.
In Assam, my lord, Bihu and fish has got a lot of connection.
Connection, Lordship. So it should be before Bihu, Lordship.
So avoid that. This hearing of the matter should avoid all.
Lordship,
No, nobody is gaining, my lord.
No.
Nobody is gaining.
Only Lordship, let it be on the before Bihu, Lordship, if possible, Lordship.
Not possible. So before Bihu, there is only 1 week.
Yes.
Or I think so only 5-6 days.
Or 28th.
I have no choice, only any date. Obliged.
Obliged. 20?
Is to be.
One delay, eventually.
Please, your Lord. My lord, here we are assailing an order passed by the DOT, thereby rejecting our interim prayer for staying the operation of section 14 order. Now,
Why don't you approach the village tribunal?
my lord, my submission will be this, my lord. That section 18 of the Surface Act, my lord, does not contemplate an appeal against the rejection of an interim order. That will be my submission, my lord. So may kindly take up this Surface Act. Section 18, my lord. May I read that, my lord?
Yeah, read.
any person aggrieved by any order made by the Debt Recovery Tribunal under Section 17 may prefer an appeal along with such fee as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order of the Debt Recovery Tribunal. Kindly read this any order in conjunction with the second proviso, man. Provided further that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of the debt due to from him as claimed by the secured creditors or determined by the debt recovery tribunal, whichever is less. I will not read the rest, my lord. Now, this expression, my lord, whichever is less has some significance here. My lord, whichever is less, it contemplates a comparison of two values and it refers to lesser of the two values. Now, under the second proviso, my lord, there shall be no appeal without this statutory deposit. That's the law. Now, what would be the amount, my lord, provided in second proviso? It says 50% of the amount of the debt due from him as claimed by the secured creditors or determined by the debt recovery tribunal, whichever is less. Now, this whichever is less to be determined, there must be comparison of the two values. Unless there is a comparison of these two values, my lord, this expression whichever is less cannot be placed into service. Now, these two values, 38. Only two values is, my lord. One is the amount claimed by the secured creditors. My lord.
Kept over here. What?
is the power of the, this, gap review tribunal to stay the proceedings?
My lord, that's a settled law, my lord.
What is that?
Kindly give me some time, my lord. Can it postpone on the, next week, my lord? I will, that's a settled law.
That's, while exercising power under section 17, the tribunal can stay the proceedings for whatever the state pass and stay order.
Stay order. DRT can pass the stay order. That's a settled law.
You just satisfy us because until and unless the DRT has the power to stay.
Yes. That I will
See,
satisfy.
whatever application you have made before the DRT.
My lord.
Saying that, and if they are refusing that.
Yes.
Then we have.
There ought to be some power. Sure. Well, I will definitely, my lord. It's a settled law.
Next week.
Next week, my lord.
And Mr. Be prepared. That this then section 18 says any appeal. Even though if an interim order is, if the tribunal has power to entertain application for a stay, then how this anybody can be enforced to file an appeal once there is a provision that he has to deposit 50% of the amount then.
That is, if any person is aggrieved by the word is any order, lordship.
Any order means order refusal of interim stay also.
That interlocutory application has been rejected. That is a separate application, interlocutory application that has been rejected. Now, if he is aggrieved, lordship, he has to file an appeal. That is civil law. And lordship, save as otherwise provided for reasons to be recorded in writing.
That is up to 25%.
25%.
We may say that once still it is at interim stage, why should I force to pay that even 25% also? Then that reason.
But well, this second proviso only says that 50% can be reduced to 25%. That's only.
Yes.
I'm saying there is no provision for an appeal against rejection of an interlocutory order.
No, lordship.
Let us see. Examine.
Can it be on the first? Can it be on the first week of my lord New Year, my lord, 25?
No. So, lordship.
25th?
Well, first week of January, my lord. Any day, first week of January.
The date may be fixed, lordship. Because what happens, lordship, the surface application is pending before the learned DRT. Now, each and every day they are taking the plea that the matter is pending in the High Court. So
that you can't take the plea because there is a 60 days limit.
That is the plea taken by them.
My lord,
and that's the order.
This interim order was passed on 2nd of February.
Yeah.
My friend entered appearance on 28th of February.
Yes.
Affidavit filed after 9 months.
We are not concerned with that, whatever it may be. But
there's the urgency, my lord.
The tribunal is mandated to decide the application within 60 days. And you can't take these adjournments. Get the matter decided. What's the problem in that? You are insisting on stay without even
otherwise
decide that.
Otherwise, this matter will be infructuous. But I'm assailing section 14 order.
Sir, maybe the tribunal may pass an
order
in favor of you.
What is the submission?
Setting aside all the measures taken by them. That is also the power, within the power of the tribunal.
Now, we are only assailing section 14 order, my lord, passed by the DM, taking physical possession.
Whatever it may be, sir.
And that matter is lordship.
Even otherwise, my lord, let it be on January, my lord, first week of January.
A date may be fixed, lordship.
Yes. Since there is no stay order in this petition, they may decide it.
That is a submission.
That's a stay order, my lord.
No.
What no?
Is pending before the court.
This
petition concept of the petitioner. A petitioner pays some time to satisfy this court that that particular tribunal is having power to pass an interim order in an application filed by an borrower under section 17 of the SURFACE. Stop. The request of the consent of the petitioner. Is this matter on?
It says any day.
You see.
Can it be on 8th, my lord?
8th of January? Yes. This made clear that no stay is operating in this petition. Yes.
Obliged, lordship.
For hearing, item 38.
I had a word with my clients. Their only concern was I informed them that lordships were tentatively of the view that these are issues which should be decided by the civil court. That in 97, 98, they had filed a civil suit against the eviction notices issued by the Assam Rifles to them. So in 2009, they were advised to withdraw that suit. That order is on record. So perhaps issue estoppel may arise that if now they go to the civil court,
In that case, then we have to decide.
if lordships, otherwise they, while disposing of the matter, if the lordships give some indication that they would be at liberty to raise those issues.
We can only say that they can raise they can file a civil suit for so and so in accordance with law. If law permits, certainly you can do that. If the law doesn't permit, it can't be done. If the law doesn't permit, we can't create a jurisdiction of a court, sir, by passing an order.
Because your lordship,
This is a limitation.
yes, I understand. Your lordship may kindly have a,
permit or there is no the jurisdiction is not vested in any court. We
yes,
can't create a jurisdiction.
yes. Lordship may kindly have the order of withdrawal at page number 239 for once.
239. Record in one of the parties. It's already there.
They were concerned that though they had prayed for liberty, while disposing it off,
Instant shoot with the liberty to file a fresh if so advised.
but while direction,
Hence the constant shoot, the disposal withdrawal. That's all, sir. You have made a mention and the court has passed in withdrawal. That means liberty is already there.
very well. If
That is
it
there.
is disposed of on that indication,
That is decided by the court, sir.
some factual determination would be necessary, your lordship. But it may not fall from my mouth, your lordship, that I am conceding the matter. That was my only concern. Lordship may dispose of the matter in those lines, your lordship, by directing the parties perhaps to go to it.
We have to pass a detailed order that may, some observations that may create some trouble. That's the only thing. Because then we have to record some findings.
Because, yes, your lordship.
That subject to whatever it may be, the final order, we are not aware. But then we have to record a finding that these persons, allotment of these persons during the currency of the allotment of the other person is somewhat, we have to make some observations.
Yes.
If we pass an order on merits then.
Because otherwise, this is my learned friend's appeal. So,
No, that's appeal.
yes.
On consent, we may say that this order may be, this order is set aside.
If my learned friend also is willing, your lordship, then perhaps it can be done.
Set aside for the purpose of setting aside the learned single judge order, your consent is required. That
Lordship,
But
unilaterally, simply on his saying, we can't set aside the order, sir.
definitely we had a discussion on this. My saying is, lordship, I have got absolutely no objection if he approaches the civil court if there is a determination on the facts.
And actually, ultimately, the matter requires determination of right.
it does, it does.
What is your status? What is their status? That has to be ascertained.
And on the other side, it helps me also, lordship.
Yeah,
I get a case.
yeah.
I get a case.
So, if you agree with the consent of the parties that we'll simply observe that whatever the dispute raised by the parties regarding compensation, relative compensation is required to be adjudicated by the civil court on the basis of the evidence, and therefore both the parties are in agreement and the impugn order is not sustainable and therefore it may be set aside and the parties be directed to are at liberty to file the civil suit.
Very well.
Without any observation.
Very well, Lord. Very well.
Having heard the learned counsel for the having argued the matter for quite some time at length, learned counsel for the appellant as well as the counsel appearing from the private respondents have frankly admitted that the dispute raised, the dispute raised before the learned single judge regarding the rental compensation to be paid to the private respondents involved several disputed questions of fact, and those facts are to be, and for resolving those disputed questions of fact, a proper adjudication by a civil court is required. To stop the net counsel appearing for the respondent has frankly admitted that as frankly admitted that the disputes, that the questions, disputed questions of fact involved in this case can only be resolved by a civil court after taking into consideration the facts and after taking into consideration the evidence adduced by the respective parties. To stop. And the counsel for the parties are in agreement that the impugned judgment passed by the learned single judge dated 24th of April 2000, 31st of May 2019 may kindly be may be set aside, and the respondents, private respondents, be granted an liberty to approach the civil court by filing an appropriate suit for redressal of their grievances. Full stop. It is noticed that earlier also the private respondents have approached the civil court by way of filing a title suit, by way of filing title suit number 5/98. However, the said civil suit came to be dismissed as withdrawn on the request of the counsel appearing for the private respondents, in which a liberty was also sought to file a fresh suit if so advised. I think so now it will take care of lordship. In view of the above submissions made by the learned counsel for the parties, this writ petition is disposed of. The impugned order dated 31st of May 2019 is set aside. However, the private respondents are at liberty to institute a civil suit before title suit before the competent civil court for redressal of their grievances. How much time? कितने दिन में? Would you like to have some time?
Some time may be granted, some time.
Within a period of 4 months.
Very well.
From today.
Deeply obliged.
Item 29.
I think so there was some
Yes, my lord.
request made on behalf of adjournment request. Who made this?
My lord, matter is, my lord, a 38-year-old young man dismissed from service in a very few months after joining. And I'll submit, my lord, not today. And my lord, he was made the scapegoat because it's a common proceeding for 8 persons. Others were allowed to go virtually scot-free. And my punishment was given, my lord, dismissal with bar for future employment. And learned single judge, my lord, set aside everything for some good reasons and reinstated me. Now this writ appeal is pending for last 1 week. So it is last 1 month, 1 year almost.
1 year.
So my lord, a date may be fixed. Of course,
Whatever date. Which date? would
I
you
don't
like?
know about your lordship. I am still not yet in my lord vacation mood.
But frankly speaking, we are in.
So immediately after vacation, then it will be in a hangover mood. Anyway, my lord,
Hangover for whom? Hangover for you people if you are engaged in party, we are not supposed to.
one side is the
We don't
vacation
have
mood
that
and other
We
side,
don't
my
have
lord,
that luxury.
7th of January.
7th of my lord.
My lord, lordship may observe that this time this may be hearing
It
number
is the
1 set.
understanding, since you have raised this objection, that's why only they were not adjourn in the morning itself. When you let them come, then only they.
Earlier
7th of January.
earlier it was observed. Obliged, my lords. The
No,
tradition-
I think so. They'll not also attempt to make an request for adjournment.
No, my lord, only.
Looking to your stiff opposition.
Yes, my lord.
Absolutely for your lordship. And the only thing I know, my lord, certain matters get precedence, my lord, like habeas corpus, dismissal of service. Like
Sir, if we have time, we have enough time, we can hear it.
So
Precedence,
it's
there is no
on the
question
top,
of
my lord.
precedence.
That your lordship out there. 7th.
7th.
7th.